Thank you, Mr. Speaker. And members, before I get started, I'd like to bring to your attention that I put a letter on each of your desks that was composed by former member David Simpson called Honor and Humility, and I would appreciate it if you would take the time to read that. Members, we're here today because the Attorney General asked the state legislature to fund a multi-million-dollar settlement against him brought by the whistleblowers. There was no investigation prior to this time. We wanted to look further into the reasons behind that. A whistleblower lawsuit was filed against the state of Texas in November of 2020, alleging that the Attorney General, Ken Paxton, wrongly fired employees for reporting their concerns that unlawful conduct by Mr. Paxton occurred. As members may know, under the Texas Government Code, Title 5, Chapter 554.002A, a state agency is prohibited from suspending or terminating the employment of public employees who reports a violation of law by another public employee in good faith to an appropriate law enforcement authority. This provision exists to protect individuals from retaliation and the public from illegal, unethical, and harmful actions of a state or local government entity, including elected officials of our state. What members should find notable about this case is the individuals involved. These whistleblowers included 4 of the most senior staffers serving under Ken Paxton at the Office of the Attorney General. They included a former DPS trooper and Texas Ranger serving as Director of Law Enforcement, Deputy Attorney General for Legal Counsel, Deputy Attorney General for Criminal Justice, and Deputy Attorney General for Policy and Strategy. These individuals were Republican civil servants who were, in many cases, recruited personally by the General to join the OAG. The individuals sought to advise him in the highest ethical standards that they had been staunchly loyal to General Paxton. While General Paxton has referred to these staff members as political employees, it is undisputed that these individuals were high-ranking senior staff members with years of legal and civil service experience and who had the highest level of access in the office of the OAG. Hardly political appointees, in my opinion. It is also undisputed that each of these individuals was fired after reporting General Paxton to law enforcement for concerns of bribery and abuse of office, among other issues. In February of this year, a settlement for the lawsuit was reached. As part of that settlement agreement, General Paxton agreed to, 1, apologize to the former employees for calling them rogue, publicly accept that these men acted as they thought was right, and agreed that the former employees would receive $3.3 million taxpayer dollars. This settlement served to stave off a trial, including the discovery process that could have brought new and important information to light. Because of this, neither the terminated employees nor the state of Texas were able to gain any more information about what transpired in that office. Most disturbingly, the settlement agreement was made without prior approval of funds and obligates the Texas taxpayers, not General Paxton, to pay $3.3 million for his actions. Of course, the Texas legislature would have to agree to payment of that settlement amount. Members, one of the key responsibilities of the General Investigating Committee is to look beyond partisan affiliation in order to take the necessary steps to protect the institution that is our state government. We do just that today with this resolution, and I would like to point out that several members of this House, while on the floor of this House doing the state business, received telephone calls from General Paxton personally, threatening them with political consequences in their next election. Thank you, members.
The chair recognizes Ms. Longoria. Thank you, Mr. Speaker and members. The process undertaken by the General Investigation Committee and staff to better understand the settlement agreement and, by extension, any investigation into unethical actions by General Paxton has maintained the highest standards of integrity and professionalism. The investigation began in mid-March and was led by a team of experienced state and federal prosecutors, former public integrity unit leaders, and law enforcement personnel. Our chief counsel and committee director brought her experience as a public prosecutor, former assistant United States attorney for the Southern District of Texas, and federal prosecutor as her role as chief counsel. We had a career prosecutor with over 25 years of experience, including experience as a division chief of a public integrity unit in Texas, a seasoned attorney with 12 years as a federal prosecutor for the U.S. Attorney's Office for the Southern District of Texas. Another dedicated prosecutor whose experience includes being chief prosecutor for major fraud and public integrity matters. A former law enforcement captain with over 40 years of experience with high-profile complex cases, and an experienced criminal defense attorney with private investigator experience based out of Galveston County who's worked many high-profile cases. The General Investigating Committee requested this team of highly qualified professionals to conduct an inquiry into the whistleblower lawsuit settlement, issues related to the lawsuit, and to make an inquiry into the policies, procedures, and actions of the Office of the Attorney General, and specifically Mr. Paxton. While these individuals are known conservatives among legal circles, they are above all professionals with the requisite skills and experience to conduct an investigation of this magnitude and importance. This team was further tasked to ensure they maintained an independent and objective investigation, and was clear with all witnesses and stakeholders that the purview of the investigation was not tied only to the whistleblower settlement, but to the broader information sought on the policies, procedures, and actions of the OAG. The team methodically reviewed hundreds of records, including court filings, reports, past depositions, and related documents, including what is commonly known as the OAG report, concerning the Office of the Attorney General's own investigation into the actions alleged as the basis of the whistleblower's lawsuit. The OAG report, I will note, serves as Paxton's statement of defense to the allegations raised by the whistleblowers and contains a multitude of statements that were disproved by our committee's investigation. And I think this is very important, members. Furthermore, the report was available on the OAG website at least as recently as May 23rd, the day before the committee's public hearing. It has since been removed. The team also conducted 15 detailed interviews of individuals involved in these allegations to further determine a timeline of events and establish consistency in background information and facts. The research and investigatory findings by the attorneys, professional investigators that compose this team act as our basis of the articles of impeachment you see before here today. We ask you, as faithfully elected members of the Texas House, to consider the overall context of these findings to determine who benefited from these actions and whether a pattern of not just unethical, but possibly criminal action is found. Thank you.
The chair recognizes Mr. Spiller.
Thank you, Mr. Speaker. Members, in a public hearing on Wednesday, May 24th, the House General Investigating Committee heard approximately 3 hours of detailed, compelling testimony from a team of highly trained and experienced investigators, including multiple attorneys who had served as prosecutors specializing in white-collar crime and public integrity cases. The testimony reported facts relating to and supporting claims of multiple instances of misconduct committed by Attorney General Ken Paxton. You have been provided a transcript of that hearing and have had an opportunity to view and consider the video broadcast of the entire public hearing. Members, it is important to provide you with a concise summary of the pertinent facts brought forth in that hearing. In doing so, I intend to focus on what I believe is the primarily relevant, the matters demonstrating that Attorney General Paxton abused his office and his powers for personal gain. I will address several issues reported to our committee. First, let's visit about Nate Paul. Nate Paul is a real estate investor in Austin. Nate Paul was also a friend of Attorney General Paxton and a donor to Attorney General Paxton. Nate Paul had a real estate business, World Class Holdings. Nate Paul was in trouble with federal law enforcement. In August of 2019, FBI agents executed search warrants at Nate Paul's home and his business, World Class Holdings. Nate Paul owned and controlled World Class Holdings, and World Class Holdings controlled a number of other entities. In November of 2019, attorneys for Nate Paul made Public Information Act requests to the Texas State Securities Board for documents relating to the search warrants issued against Nate Paul and his businesses. The State Securities Board requested an Attorney General's opinion as to whether or not it was required to release the records. The Attorney General's office issues approximately 30 to 40,000 open records decisions each year. There is no evidence that Attorney General Paxton had ever taken a personal interest in any of those decisions except for this one that related to Nate Paul. Although the requested information clearly fell within the law enforcement exception and would not have to be released, Attorney General Paxton pressured the OAG staff to issue an opinion that would have allowed for the records that Nate Paul sought to be released to Paul. A highly unusual move that was contrary to well-established precedent relating to protecting the integrity of criminal investigations. Despite pressure, the OAG issued a ruling that all records relating to the request were not subject to disclosure due to a pending criminal investigation of Nate Paul. In March of 2020, Nate Paul's lawyers tried again, this time making a Public Information Act request to the Texas Department of Public Safety for documents relating to the search warrants issued against Nate Paul and his businesses. DPS, you see, had cooperated with and assisted the FBI in the execution of the search warrants against Nate Paul. Because the search of Nate Paul's home and businesses was conducted by the FBI filed a brief with the OAG urging the OAG to follow its longstanding practice, policy, and procedure of not providing documents relative to an ongoing criminal investigation. A redacted version of that brief was sent to Nate Paul's attorneys, but Nate Paul wanted the unredacted version. And Attorney General Paxton tried to help him get it. DPS requested an Attorney General's opinion as to whether or not it was required to release the records. Again, Attorney General Paxton pressured a Deputy Attorney General to issue an opinion that would have allowed for the records that Nate Paul sought to be released to Paul, including the unredacted FBI brief. Attorney General Paxton revealed that he had spoken personally with Nate Paul and told OAG staff that he didn't want to help the FBI or DPS in any way. Attorney General Paxton then took the entire file that had all of the responsive documents, including documents sealed by a federal court, and didn't return them for approximately 10 days. Attorney General Paxton then directed that the final opinion be issued and that the OAG take no position on whether the documents should be released. Then, in May of 2020, Nate Paul's lawyers made another Public Information Act request, this time to the OAG, seeking the unredacted FBI brief. Attorney General Paxton directed the same Deputy Attorney General to find a way to release it to Nate Paul and to draft an opinion authorizing the release. Attorney General Paxton then directed an aide to deliver a manila folder directly to Nate Paul at Nate Paul's place of business. The contents of the folder were never disclosed to OAG staff, and Nate Paul never followed up to attempt to compel production of the requested documents. Presumably, there was no need to. Next, let's talk about the Mitty Foundation. The Roy F. and Joanne Cole Mitty Foundation is a nonprofit corporation and charitable foundation located in Austin. Aside from performing a number of charitable purposes, it invested in and was a limited partner of several entities controlled by World Class Holdings, again, Nate Paul's company. The Mitty Foundation filed suit against several of those entities controlled by Nate Paul's World Class Holdings, claiming, among other things, that the Mitty Foundation was being denied access to the books and records of the companies, a right generally that every limited partner has. The litigation grew and later resulted in a court-appointed receiver being appointed over the entities. Now, the Financial Litigation and Charitable Trust Division of the OAG is entitled to receive notice of any litigation involving a charitable organization in the state of Texas. The OAG can intervene in such cases if the determination is made by the OAG that it's necessary in order to protect the assets of the charity. In January of 2020, after receiving notice of the pending litigation, OAG lawyers in the Charitable Trust Division filed a notice with the court declining to intervene in the case, a standard practice and reasonable under the circumstances since the Mitty Foundation was well represented by very capable counsel. However, in May or June of 2020, Attorney General Paxson began to take a deep personal interest in the case. The OAG has approximately 35,000 open civil cases each year, but this is the only one that Attorney General Paxson had ever taken a personal interest, the one involving Nate Paul. Attorney General Paxson had several discussions with the OAG staff about intervening in the case. Against the advice of the OAG staff and contrary to the OAG's prior determination not to intervene, Attorney General Paxson directed the Charitable Trust Division to intervene in the lawsuit. After intervening, Attorney General Paxson instructed a Deputy Attorney General to review the pleadings in the case. That Deputy Attorney General informed Attorney General Paxson that the OAG had no interest in the case, the OAG shouldn't waste its resources on the case, and that the parties in the case had already reached a $10.5 million settlement agreement, which Nate Paul subsequently breached. In other words, he defaulted on his obligation to pay the $10.5 million. The Deputy Attorney General strongly advised Attorney General Paxson to have nothing to do with Nate Paul and to get out of the case. So intense was Attorney General Paxson's desire to help Nate Paul in the case that he even suggested personally attending and appearing before the court, which would have been unprecedented. Attorney General Paxson directed OAG staff to file a motion to stay the case, in other words, stop the case, to force a mediation, a move which hurt the Mitty Foundation's position in the case and only helped Nate Paul's position, a position contrary to the best interest of the Mitty Foundation, to which the OAG's office had a fiduciary obligation due to its representation. Based on Attorney General Paxson's directives, the OAG attempted to force the Mitty Foundation to settle the case for about $5 million, less than half of the $10.5 million for which they had previously agreed to settle. The OAG subsequently withdrew from representation. The case moved forward, and the Mitty Foundation recovered a judgment for $21 million from a forced sale of some of Nate Paul's properties. Meanwhile, Nate Paul continued to have financial problems. 13 properties belonging to Nate Paul's business entities and to which Nate Paul was a personal guarantor were scheduled to be foreclosed upon on Tuesday, August 4th, 2020. Approximately 4 days before that, on Friday, July 31st, 2020, Attorney General Paxson contacted OAG staff to look into whether restrictions on in-person gatherings due to COVID could prevent foreclosure sales of properties. Attorney General Paxson then made it clear that he wanted the OAG to issue an opinion by Sunday prior to the sale, stating that foreclosure sales could not be permitted to continue. That was contrary to established law, policies, and procedures, and that there was no written request for such an opinion from a qualified requester, and the time frame for responding to a request like that is typically about 180 days due to research, preparation, analysis, and review. When asked who requested the opinion, Attorney General Paxson gave no name, produced no letter requesting the opinion, and only gave staff a phone number which was incorrect. Attorney General Paxson was wanting the opinion letter done in 2 days, over the weekend. The opinion letter was prepared and issued, but was never published, as are other opinion letters. The effect of that opinion letter was used to thwart the foreclosures of Nate Paul's properties. In May of 2020, Attorney General Paxson contacted the Travis County District Attorney and requested a meeting to help Nate Paul present a criminal complaint against federal and state law enforcement officials, prosecutors, and judges. The complaint was presented, but Nate Paul refused to swear to the truth of the allegations contained in the complaint. As expected, the Travis County District Attorney refused to have anything to do with an unsworn complaint and referred it to the OAG. Staff at the OAG investigated the claims and determined that no credible evidence existed to support any criminal charges. Attorney General Paxson, however, disagreed and insisted that a criminal investigation move forward. In August of 2020, Attorney General Paxson sought OAG staff assistance in seeking outside counsel. That would have been a violation of OAG policies and procedures, in that the OAG seldom seeks outside counsel on criminal cases, due in large part to the fact that they've got approximately 800 assistant attorneys general on staff to handle criminal matters. But Attorney General Paxson was informed that the OAG's approval process for handling outside counsel requires authorization from at least 10 different OAG personnel throughout several stages, all designed, at least in part, to prevent the hiring of unqualified, conflicted lawyers. Further, the process is designed to be able to draft and approve a contract to make assessments, approvals for funding, and things of that nature. However, again, hiring outside counsel for a criminal case is seldom necessary. Attorney General Paxson later fought assistance on the ability to retain outside counsel to investigate criminal allegations. Attorney General Paxson was advised that Texas law only allows that in a couple of circumstances. One, if a prosecutor recuses himself or herself and the trial court appoints an attorney pro tem as a prosecuting attorney, or two, if a prosecuting attorney requests the assistance of the Attorney General and the Attorney General offers the prosecuting attorney the assistance of his office. Attorney General Paxson later informed OAG staff of his decision to retain Brandon Kamek, a criminal defense attorney who had been licensed only 5 years and had never served as a prosecutor. It was later disclosed that the source of the referral, where did Kamek come from, was, of course, Nate Paul. Attorney General Paxson instructed OAG staff to draft an outside counsel contract and send it to Kamek immediately. Kamek approved the contract but didn't date it, and began acting under the guise that he was approved by the OAG, although the contract had not yet been approved. OAG staff refused to approve the highly irregular contract. Attorney General Paxson continued to be involved, meeting with and pressuring staff to approve the contract. OAG staff continued to refuse to approve the contract and notified Attorney General Paxson that the contract was not yet approved. Despite this non-approval of the contract to retain Kamek, Attorney General Paxson instructed Kamek to begin work. The contract was never approved. The contract, even if it would have been approved, did not identify Kamek as a prosecutor. It specifically stated that Kamek was not to provide indictment or prosecution legal services. Despite this, at the instruction of Attorney General Paxson, Kamek proceeded to conduct work and falsely represent himself as a special prosecutor in order to obtain 39 grand jury subpoenas directed to Nate Paul's adversaries relative to the Nate Paul complaint, which were directed to the very law enforcement agencies and entities contained and specific documents referred to in the FBI unredacted brief that Nate Paul was never to have received a copy or access. The parties and information contained in the subpoenas would not have been knowable unless someone had access to the unredacted FBI brief. The subpoenas were signed by Kamek as special prosecutor. Further, Nate Paul's lawyers accompanied Kamek when serving one or more of the OAG subpoenas. All of these actions were taken under the instruction, involvement, and approval of Attorney General Paxson. When the OAG staff learned of the issuance and service of the subpoenas, they had them quashed or canceled. In summary, what I've outlined to you is not an exhaustive list of the claims and issues presented to our committee. It is, however, a compelling substantiation of the fact that Attorney General Paxson abused his office and his powers for personal gain. Attorney General Paxson continuously and blatantly violated laws, rules, policies, and procedures, improperly and illegally using OAG staff, resources, and monies to intervene and interfere in the civil disputes and criminal matters of his donor and friend, Nate Paul, and benefiting himself. Members, I remind you that your function in this process is to act somewhat in the capacity of a grand jury. An impeachment is similar to a criminal indictment and must be followed by a trial in the Senate. You don't have to have proof of anything beyond a reasonable doubt or by a preponderance of the evidence. The House decides only if there is sufficient evidence to justify further legal proceedings. Today is a very grim and difficult day for this House and for the state of Texas. Attorney General Paxson has a brilliant legal mind and has worked diligently for the state of Texas. I have great appreciation and respect for the many, many things that he has done for this state. Frankly, Attorney General Paxson deserves praise for his fierce, consistent efforts to push back on behalf of Texas against unconstitutional federal mandates, executive orders, rules, and laws. But members, no one person should be above the law, least not the top law enforcement official of the state of Texas. We each took an oath of office. Attorney General Paxson took an oath of office. He violated that oath. He put the interest of himself above the laws of the state of Texas. He put the interest of himself over the established laws, policies, and procedures of the Office of the Attorney General. He put the interest of himself over his staff, who tried to advise him on multiple occasions that he was about to violate the law. He put the interest of himself over the top officials in the Office of the Attorney General that he fired and retaliated against for reporting in good faith their belief that he violated the law. He put the interest of himself over the lawful functions of the FBI, the DPS, and other law enforcement agencies and prosecutors in their attempts to investigate and prosecute criminal activity. He put the interest of himself over the taxpayers, whom he asked to foot the bill for millions of dollars to pay for his illegal activity and to pay for his personal interest, all without having to answer any questions under oath about his activities and actions. And he put the interest of himself over the citizens of the state of Texas. Members, it brings me no pleasure to be standing here today in front of you dealing with this matter. I know that it's not pleasant for you either. But we have a duty and an obligation to protect the citizens of Texas from elected officials that abuse their office and their power for personal gain. As a body, we should not be complicit in allowing that behavior. We should not ignore it and pretend it didn't happen. Texas is better than that. Thank you, members.
Without objection, members, Ms. Ann Johnson will make the final opening statement. Her time will not affect the time allocated for questions. The chair recognizes Ms. Johnson Harris.
Thank you, Mr. Speaker. The last 72 hours has shown us why Ken Paxton is so desperate to keep his case in the court of public opinion. Because he has no ability to win in a court of law. See, in a court of law, a judge will preside over that case, and he will be treated just as any other civil or criminal defendant. Witnesses will be under oath for all the world to see. And this past Wednesday, 2 investigators and 4 career prosecutors with decades of work in public integrity and white-collar crime revealed that they had confidentially been interviewing witnesses and reviewing evidence into Attorney General Ken Paxton for months. Public integrity means looking into and prosecuting elected officials who have used their office for their own gain. This body, we, have passed numerous laws to protect the public from corrupt officials, like abuse of official capacity, official oppression, misuse of official information, bribery, and corrupt influence, all of which we have here. White-collar crime, not your pickpocket, the use of complex systems that can destroy companies, wipe out people's life savings, cost investors millions of dollars, and erode the public trust in institutions. Crimes like mortgage fraud and securities fraud. These are not new concepts to the committee's investigative team, but their discovery that the state's top cop is on the take was and is extraordinary. Criminals have an MO, a modus operandi, a method of operation, just like any common theme of a thief, a rapist, a murderer, where they have patterns that can develop over time. And Paxton has shown over time he has a power in his ability to not respond until caught. Once he has learned he is caught, he will often lean on political friends, delay the process he could to avoid the courtroom, and lie to the public for almost a decade, thinking his reelection served as the ultimate get-out-of-jail-free card. We sit here to judge like any other grand jury to decide whether or not we want to move forward. And criminals rarely confess. That is why we don't have to prove motive, and we don't have to prove cases in any other way than ideas such as circumstantial evidence. And so let me explain circumstantial evidence. We have all been in the grocery store, and I want you to imagine that you turn down the aisle, and as you start down the aisle, you see another person coming the other way. They're pushing their buggy. They've got a child sitting there in the top of it. They're reaching up for items. They're looking down at their list, and as you get to each other, "Oh, I'm so sorry. Are you okay? I didn't mean to hit you." Do you think that they meant to hit us? You can see all the circumstantial evidence around it and say, I don't think they meant to hit us. Now let's take that we turn down the aisle, and on the other end of the aisle there's a cart coming, a person pushing, no distractions, no baby, no list, and they're coming right for us. And we move over the other way, and they come in our lane, and we move over the other way, and boom, I'm sorry, I didn't mean to hit you. Do you believe that? It is the same analysis that we go through in looking at an entire timeline when determining criminal activity. We also are not required, when a potential offender tells us a statement, that we have to take them at their word. We look, and we are responsible for evaluating and looking at all the circumstances. And so let's take a look at what's happening with Texas Attorney General Ken Paxton. It's around October 2020, and the office is beginning to scramble in a crisis. Calls are starting to come in because there are agencies and entities receiving subpoenas that they are wondering, what in the hell are you doing? Are you really looking for this kind of information? At that point, they are aware that there are more than 30 subpoenas that have gone out to banks, asking for loan information, checking and saving account information, personal cell phone data of bankers, investigators, and a judge. They begin to recognize that these subpoenas are supposedly authorized by Brandon Kamick. Who the heck is that? You have these entities of operations of men who have been in different silos who all come together, and they all, at that point, sitting around with each other, realize that there is a common thread that they are hearing, and they all perk up. They realize the conduct that the Attorney General has independently been committing with each of them over a course of a number of months. All roads lead to Nate Paul. All of them recognize through their own independent discussions with the Attorney General, they have warned him, Nate Paul is no good. You can do a common Google search and see his bankruptcies, and there is no way you should have anything to do with him, and there is no way this office can participate in anything on his behalf. Article 1. When Ken Paxton asked the Office of the Attorney General to interfere in the Mitty Foundation, as Representative Spiller has spelled out, he turned the Attorney General's office against a nonprofit. As the lawyers for that nonprofit said, quote, they felt ominous pressure, being forced to attempt to settle on the cheap to the benefit of Nate Paul. When the Office of the Attorney General suggested that they settle for $5 million when they had a $10.5 million already recognition of Nate Paul was supposed to provide, and then later being recognized that the value of that case to them was $21 million. You heard from Representative Spiller that unusually Ken Paxton involved himself in these matters in a way he had never before done with regard to a charitable entity. He broke the fundamental rule that this body has passed to say that the Attorney General will protect nonprofits for the interest of the vulnerability of all Texans. And in this case, he turned that on his head, represented his friend, and he broke the law. This article represents abuse of official capacity, which is a third-degree felony warranting 2 to 10 years in prison. Article 2, when Ken Paxton asked the Office of the Attorney General, as Representative Spiller just displayed, what they called the midnight opinion. Nate Paul has 13 properties that are in foreclosure, and they know that he has one or more set, or he knows that he has one or more set this next Tuesday. They go scrambling, and they originally write an order that says there is no need for us to shut down. Ken Paxton says no, do it the other way. They acknowledge to him and say, you do get that we're going to say that while it's COVID, that 10 people can't get together outside for foreclosure, and that goes against every other policy that was being issued at the time by the state with regard to COVID. They issue it anyway. When Nate Paul is deposed and he is asked, did you have contact with Attorney General Ken Paxton before that order was done? Quote, yes. I had contact with him before that, end quote. Ken Paxton, he broke the law. This is misuse of official information, another third-degree felony warranting another 2 to 10 years in a prison. Article 5. When Ken Paxton sets up this rare lunch, he asks the Travis County DA's office to sit down and meet with Nate Paul. He makes a personal introduction. As a courtesy, the Travis County DA stays. They listen to Nate Paul, and they think there is nothing here for us to do to investigate. He insists that he wants them to try to help him because he believes that he has been falsely accused and needs to get access to information with regard to the FBI. They require that you give a sworn statement. And the reason they want you to give a sworn statement is you want to try to prevent people from using law enforcement agencies for false and vindictive purposes. He doesn't give a sworn statement. Travis County says, nothing for us to do here. There is no there, there's no case there. Ken Paxton then assigns Mark Penley, Deputy AG, and David Maxwell, the Director of Law Enforcement, to meet with Nate Paul and to meet with him. They again tell Ken Paxton, quote, no evidence of a crime and no state interest, end quote, is here. There is no reason for us to get involved or have anything to do with this guy or his allegation that the federal government has tampered with him. Ken Paxton insists, do it again. At this point, Nate Paul comes back and he has some records that he suggests have been tampered. The Attorney General's office then has an expert go through the point of doing analysis on the document and again comes back and says, there's nothing wrong here. This document has not been tampered with. Ken Paxton says, I just need you guys to meet with Nate Paul and tell him. They again sit down in a room with Nate Paul, Ken Paxton, and these senior officials, and they say, look, there's nothing here that this office can do for you in this circumstance. They describe that Nate Paul gets, quote, incensed, end quote, and, quote, dresses them down, senior staff, like they were his employees, end quote. These two men for decades say, we're not getting involved, we're not doing this. As Representative Spiller said, there are some 800 lawyers that can engage in criminal issues. Ken Paxton, Freudian slip, decides that he's not going to let it go. Ken Paxton is going to now look at two different individuals to hire to act as a special prosecutor, one of which is decorated decades of experience in prosecutorial experience, and the other is a 5-year lawyer, defense attorney, and never been a prosecutor. Guess which one gets hired? The guy that's got no prosecutorial experience, and it's because he comes at the recommendation of the attorney who works for Nate Paul. Ken Paxton sets aside money for this young individual to work, and he tells Penley that he needs to hire him. Penley refuses and will not sign the contract. He says no. Ken Paxton again asks on a Saturday, come meet me, I want to talk with you. They meet in McKinney, and when they do, Penley again warns Ken Paxton, quote, you are exposing yourself to potential criminal liability, end quote. He says, do not do this. And Ken Paxton says, you got to sign the contract. He's been working for 2 weeks. He needs to get paid. Penley then says, fire him. I will not participate and I will not supervise this guy. And Ken Paxton responds, quote, don't worry, I will, end quote. The grand jury subpoenas that are put out include bank records, individuals, and contacts as already recognized with regard to investigators and a judge in a case involved with Nate Paul. This raises serious questions about the release of public information. It raises serious questions about exposing a search warrant. And why do we have search warrants and why do we redact them? Because we appreciate law enforcement. We appreciate those witnesses that will come forward in the interest of justice, and we do not turn over those files to a target because what can happen? Witnesses can be tampered with and evidence can go missing. It is a fundamental tenet of offices of prosecution and law enforcement that you do not expose those individuals. But as Representative Spiller has already indicated, there is a correlation between the access of that unredacted file and Ken Paxton to Nate Paul, and sure enough, it is those individuals and their information that's being sought in this warrant. One of those investigators later goes to get his car fixed, and when they get the car fixed, you know how they raise it up? He says, hey, can I take a look underneath? And finds a tracker, and finds that that tracker has been active in searching, and it's been on around the time that these things start happening. Ken Paxton broke the law. Misappropriation of fiducial property, which is a state jail felony, carrying 6 months to 2 years, and another case of bribery, carrying a second-degree felony of 2 to 20 years, and abuse of official capacity, another third-degree felony carrying a punishment range of 2 to 10 years. Article 3 and Article 4, when Ken Paxton asked that they issue this no decision, when you have the receipt of the manila folder that he has for 7 to 10 days, when we know, like any other criminal who wants to cover his tracks, he doesn't hand it to Paul himself. He gets a young aide, gives him the package, and asks him to deliver it to Nate Paul at one of his Austin businesses. Ken Paxton, again, broke the law. Misuse of official information, abuse of official capacity. Again, an additional third-degree felony warranting 2 to 10 years in prison. When these whistleblowers, these individuals find out what's happening, they begin desperately to start cleaning up Ken Paxton's mess. They recognize that those 39 grand jury subpoenas that go out, and let me explain how this happens. The Attorney General typically will assist in other counties. So it is not unusual that they went to Travis County and they said, I need to issue these grand jury subpoenas. A grand jury subpoena carries weight. It means you must comply. And if you don't, you're in violation of the law. It was issued by, quote, Special Prosecutor Brandon Kamek, and it was signed by a judge. It is the Attorney General's office themselves, these entities, these individuals who started to see when it boiled over and realized what was happening around Nate Paul, that they go file motions to quash. A motion to quash means I'm telling you, you no longer have to respond to this order, and in doing so, they say that the individual that had submitted them did not have the authorization and should not have done it, and they should not comply with that response. Articles 9 and 10. Articles 9 and 10 relate to the issues of the affair and the renovations. Why is the affair important? The affair is important because it goes to Ken Paxton's political strength. He knows that with his folks, he is family values. He is a Christian man, and the idea of the exposure of the affair will risk him with his base. In fact, when the affair comes out, there are a couple of people in the office that say, I can't work for you, and I'm leaving. He has an interest in attempting to keep this affair quiet. He also has an interest in continuing it. Another staff member says that he comes to them distraught of how he is continuing to be in love, and she tells him, what the heck are you doing? You are exposing yourself and you are exposing this office to potential blackmail and potential influence, and you can't do it. The other benefit is that Nate Paul giving his mistress a job means that he no longer has to drive back and forth from San Antonio to see her, and it makes her more convenient and here in Austin. With the renovations, you may have heard part of the story with the renovations is that they have a home here in Austin that is undergoing floor-to-ceiling renovations. The idea of this is that there is a young man with Ken Paxton. He normally has a security detail, but he starts doing things without that detail, and he starts doing things that are not on his schedule. One of those things is going to this renovation house, of which there is a disturbing encounter. This young man realizes that as they are standing there in the home, and Ken Paxton says, hey, we want to change out these countertops and get something else. And they say, that's going to be like $20,000. That's all right, go for it. The contractor says, I'll have to talk to Nate. This young man is disturbed by it. In fact, he's crushed by it. He believes Ken Paxton is one of his heroes. He is a leader of the Republican Party, and he is the Attorney General. This young man is bothered by it enough that he eventually asks him and says, hey, what was the deal with that? And this young man does not get an answer of which satisfies him. The whistleblowers now come forward and disclose their information. It is after that that this young man is offered a promotion. He declines, and he leaves the office. After he leaves the office, he continues to get a stipend and a check from Ken Paxton's campaign for $250 a month. He calls repeatedly, says, I don't want this money, please stop it. It goes on for about 4 months. At the point in time that it finally stops, he writes a check and he sends it back to the campaign without anybody knowing about it. This is the kind of integrity of the people that we describe when we say that the committee investigators have met with more than 15 people, many of them Republicans, many of them who worked in the office as civil servants, and many of them deeply conflicted about the information about what they had to disclose and the individual, because each of them, almost to a fault, attempted to remain loyal and help Ken Paxton. In these 2 articles, again, Ken Paxton, he broke the law. He received an improper gift to a public servant, a Class A misdemeanor carrying up to a year in a local jail. He again has the appearance of bribery, a second-degree felony. You all get to judge, like that cart coming down the aisle. Are these just individual isolated incidents of which you can dismiss, or are they an unexplainable pattern of ongoing criminal conduct? Articles 12, 13, 14, and 16, these relate to the underlying securities fraud, failure to properly disclose and register. And I think that Speaker Guerin said it best in our hearing if you were watching, because at one point there was a discussion about a $100,000 gift given to Ken Paxton. And the issue was the fact that he originally did not disclose it as a securities operator to say, hey, I have a vested interest in what I'm getting, and it's either an improper donation and disclosure, of which he is aware of the laws and obligations for transparency, and when he gets busted on that, he says, no, it's just a gift. And somebody says, what do you mean it's a gift? And he says, I met a guy in a Dairy Queen, and he told me God told me to give you this $100,000. Speaker Guerin said it really well. I have never had anybody come up to me and said, God told me that I should give you $100,000. That's not the only $100,000 incident. There is another $100,000 gift, which is a donation to his legal defense fund, and there is another questionable securities issue gift with regard to the Maori Corporation. We see, like in those circumstances, that it is his opportunity to delay and extend the court proceedings that keep him from never having to go to court. We bring those incidents to you to look at that whole aisle, to determine the course of conduct that he has set in motion for almost a decade. Is that part of his MO? It is when he gets caught in those circumstances that he will say, oh no, I'm sorry, I forgot, I didn't realize, I should have registered it this other way. There are probably a lot of folks in here that speed. You may have a lead foot. And I now want you to think about how many tickets you've gotten, because you've spent a whole lot more than you've been caught. And these are 3 instances of payments of large amounts of cash to a man that he did not attempt to correct until busted. Articles 6, 7, and 8 deal with the whistleblowers. These individuals who were doing everything they could on behalf of the state of Texas and everything they could on behalf of that office, they were fired. They were not only fired, they were shamed. It stained their reputation and it stained their careers as great public servants and law enforcement officers in an attempt for Ken Paxton to save his own skin. Through this investigation, those individuals have been talked to, but I will tell you there are others. There are those that are not yet brave enough to come forward, and we won't judge them. Because it's almost like, why would you? This guy has gone almost a decade manipulating the processes, throwing false narratives out, and almost proving himself to be untouchable. We see that same MO starting now. Complaints of process, and I haven't gotten to tell my story. This is his story. This document, almost 400 pages, was sitting on his website for years. This is his answer to the whistleblower's complaint. This document went missing after we said, don't do anything with any of the evidence in this case, and you are currently under investigation. I guess it is hard to walk into a committee and claim nobody has asked you any questions or looked at process if this sucker's still sitting on your website. It is gone, and it is illogical that somebody wouldn't have realized that we would have printed out a copy. Not only did we print out a copy, but the committee investigators reviewed this report, and in the hearing, you can start on page 124, line 10, and you can go all the way to 130:19, where the investigators say not only did we review everything and talk to the witnesses involved and looked at the evidence, but page 46, false claim. Page 5, false claim. Again, page 5, false claim. Page 49, false. Page 5, misleading. Page 49, false. Page 50, false. Page 6, false. Pages 5 and 6, false. Page 42, false. Page 52, false. Page 7, misleading. Page 39, false. Page 39, again, false. Page 39, false. Page 39, false. Again, accusation, false. Accusation, false. Accusation, false. Page 34, false. And then asked, do you want me to keep going? Please. False. Page 52, false. Page 56, false. Shockingly or not shockingly, Ken Paxton's office investigation into whether or not Ken Paxton committed his own crimes has been and recognized to be repeatedly false. Again, with regard to the whistleblowers, Ken Paxton, he broke the law. Retaliation under our government code is a felony of the 3rd degree carrying another 2 to 10 years in prison. Official oppression is a Class A misdemeanor warning a year in a local county jail, and the government code 55.4.002 of the whistleblower statute and civil penalties. Articles 16, 17, and 18 go to the ideas that this gentleman is no longer fit for service or for office, that what he has done has impugned the integrity of our court system and those who have worked very hard to keep it functioning. We asked a question to the committee investigators about what they found about those whistleblowers and the courage that they demonstrated. Quote, the thing that I think struck all of us in our investigation, not only in speaking with whistleblowers, but other high-ranking officials at the Attorney General's office, is that these are individuals who are extremely well-credentialed and qualified. These are individuals who had taken upon their role as public servants to do their oath. Is what their oath asked them to do, to uphold the laws of the state of Texas and to uphold the Constitution. Many of the people that we spoke with, specifically some of the whistleblowers, are known outside of the office of the Attorney General's circle. They are well-respected former law enforcement. They are well-respected attorneys. They're individuals who are considered subject matter experts in the field, and they are oftentimes the cream of the crop. They rose to the positions that they are in because of their work ethic and because of their dedication. And the feeling was shared almost universally that the actions that they were being asked to take, the positions that they were being put in, and the decisions made by the Attorney General sullied their office and sullied their commitment and their careers. I've had the opportunity to work in criminal courts for almost 20 years, and I feel for you in the same way that I feel for jurors. Nobody asked to have to be brought in to make these judgments. But I will say it is not you who asked to be here, but it is the person who continually broke the law. And that man is Kenneth Paxton. This story now comes to the fork in the road for all of us. And either this is going to be the beginning of the end of his criminal reign, or God help us with the harms that will come to all Texans if he is allowed to stay the top cop on the take. If millions of Texans can't trust us to do the right thing right here, right now, then what are we here for?